sort of that difference between, and if I'm not registered like Nicole, am I still able to access things? What's the process there, I guess?
Right. Good morning, and it's really great to be here. I think that I find both stories very intriguing. The first thing I would say is that copyright is possession, and many of us haven't transitioned from a place where we think that, I need to be recognized for it, to transitioning to a place where I know I own it and it's possession. Just like somebody can take your house, somebody cannot take your private property. So it's private property, but it's intangible in its sense, so it becomes a little nuanced. In Ghana, you don't need to register with the registry in order to have a right to copyright protection. However, there's a list of works that is recognized, and work must be, so if you have an idea, it must be expressed in tangible form. It must be clear that it is your independent work. So once you can express it in tangible form, it is a work of your independent effort. You can register as she did, which is a good, because then the registry becomes evidence that you have it. Yeah. You can bring that up as the fact that you have registered your copyright. But if even you haven't, you still have a right to the work as private property. And so in scope of how to have access to work, usually what you would meet artists when they create stuff, because there's a lot of collaboration. The real question is, how do you nuance who owns what in the process? And that has become the challenge I have in many clients we have seen. That is what you realize, which is what brings a contracting. I just differ with Gilbert a little on not needing a lawyer, but that's by the side. But I think that generally having a clear-cut contract that is very specific as to who owns what, even if it's a commission work like his, you as the creator, you have what we call the moral right. The economic right may differ. You may give your economic rights away, but it has to be clearly spelled out as to who owns what. And so contracting becomes sort of the only way I know how to deal with all the collaborators on projects. Yeah.
And Carla, with working...
Falling into what our law will call permitted use, or what he referred fair use, right? And so people...
Can you define fair use for us?
Because it is property, but there's also a public good, that there is a need to push society to a certain level of good. Some works are considered, in some limited sense, that the public may use them for the betterment of society. And so typical clauses you'd find in law across the world, you would find that for exclusive personal use, whilst the work is being made public. So if it's a music, I can listen to it for, so exclusive personal use. You would also find that it's very common to say that if it's for educational and illustrative purposes. And so if anybody uses the work made public for purposes of education or illustrative purposes, whilst recognizing the moral right of the creator, it would usually fall under permitted or fair use. So those are some limited sense in which putting your work on social media and things like that in terms of how it may feed off. But I find an evolving trend quite interesting, which is generative AI, artificial intelligence, and generative technologies. And so if you put a prompt to create a picture, who owns that picture? Particularly that we say that the work must be an original, it must be original to you. Who really owns that? I think it's still evolving. It's still a very evolving conversation in the circles. I know that ethically it seems to be off because you didn't create it. But I know that people have written books. That there was a conversation on, I think, BBC, where somebody did recognize that they use a prompt to sell a book, and they are selling the book. So they are benefiting from the economic right, but the moral right may be questionable. So those are nuanced conversations. So if he created a picture with AI and I used it, can he sue me in court and say, that's my image? So those are very nuanced, emerging conversations. We're yet to see how it evolves over the years.
Any final comments before we go to questions? I think so that we can have a bit more of a...
So
on
two
that a little
things.
bit,
I think that there was a conversation around patent. I just want us to distinguish the intellectual property right. There are things that range, that there are categories of rights within the whole body of intellectual property. Patent is for inventions, and it's first in time. So that is a very specific, more detailed conversation on things that are inventive. And it must have an inventive step, as we call it. So there's a bit more around it. But there's also trademark, which on the scale is very useful, and maybe a little more global than you would have a copyright. Now, on the question of fees, I think she's answered it. But do speak with your lawyers. I think that it's always good we understand that it's always about the value proposition. Lawyers who see the industry do not struggle to... I've done work with different people. If you see the value, it's not difficult to sell them on the project. So I would say do speak with your lawyer, and you can reach an agreement that is beneficial to both of you.
Great. So we'll take two more questions.